My name is Denise Evans with Butler Evans Real Estate, and this video is about redemption after an Alabama foreclosure. It is not always necessary to come up with the money right away. When someone loses property through a foreclosure in Alabama, they can get the property back afterwards through a process called redemption. Basically, they have to pay whatever the winning auction bid was, plus interest, and in some circumstances, some additional charges. For things like apartments or investment properties, someone has to redeem within 1 year after the foreclosure auction or lose the right forever. That time limit is very strict. And you can't just say, I want to redeem before the deadline. You either have to actually have the money and offer it to the current owner by the deadline, or you have to file a redemption lawsuit by the deadline and pay the money into court at the same time. This video is about a particular strategy when you don't have to do either one of those things. You don't have to have the money right away. So let's visit with Carol Skelton and Jean Wilhite. Carol borrowed some money to buy an apartment complex in Tuscaloosa. She gave a mortgage to the bank. A few years later, the loan defaulted. The bank foreclosed on May 31st, 2002, and an investor, Jean, bought apartments at the auction. About 10 months later, well within her 1 year deadline, Carol wanted to redeem and get the apartments back. We'll call her the redemptioner from now on. Well, the redemption dance started when the redemptioner sent a certified mail return receipt requested letter to the investor demanding redemption and an itemization of the amounts due. The investor received the letter on March 25th, 2003. The investor had a 10-day deadline to respond or lose valuable rights regarding payment for some additional charges. The investor mailed his reply by certified mail return receipt requested on March 28th, 3 days after he received the demand. Well, time passed and the redemptioner got tired of waiting. By April 11th, which was 17 calendar days, or 12 business days after the investor received the redemptioner's demand letter, the redemptioner still did not have the investor's response to the redemption charges. The redemptioner filed her redemption lawsuit that same day, April 11th. She also claimed in her lawsuit that because the investor missed his 10-day deadline, he forfeited his right to be paid some of the additional charges allowed under the statutes. The redemptioner did not pay any money into court. Normally, that would be fatal, but she still had 2 more months of redemption time to fix the problem. Well, the investor's letter finally showed up on April 16th, after the redemption lawsuit had been filed. The redemptioner still had about 6.5 weeks to pay her money into court, but she didn't think about it. The investor just laid low and didn't mention anything. After May 31st, when it had been more than 1 year since the foreclosure, the investor filed a motion to have the redemption lawsuit dismissed. He claimed the redemptioner no longer had any redemption rights at all because she failed to pay her money into court, failed to stop the redemption clock from ticking down, and it was now more than a year after the foreclosure and too late to fix things. Well, the lawyers battled it out. The redemptioner said she was excused from paying the money into court because she didn't have the investor's response in time. In other words, she didn't know how much to pay into court. Well, the court agreed. The investor said, well, that might be true, but when the redemptioner did get the letter 6 days later, she should have paid her money into court at that time. The court disagreed with the investor. The court's reasoning was that filing the lawsuit after waiting more than 10 days for the investor's response excused paying the money into court and stopped the redemption clock from ticking down to nothing. And once the clock stops, it stays stopped. Well, why do you care? If you find yourself in the investor's shoes, wouldn't you rather know the law ahead of time instead of paying $10,000 or more in legal fees to get the education from the courts? And don't you think that the investor wished he'd overnighted his response to the redemptioner or hand delivered it to her? She would have had to have come up with all that redemption money right away and paid it into court and might not have been able to do it. And finally, if you're in the redemptioner's shoes and want to redeem, you might want to look at these time limits and what happened in this case and plan a strategy that lets you take advantage of that. So if you So, if you want to read the decision, you want to read Skelton v. J&G LLC at 922 Southern 2nd, 926, Alabama Court of Civil Appeals, 2005. Now, note the same parties had another appeal on a different issue with a 2006 date for the decision. Make sure you read the right decision if you just do an internet search on the names. In the second decision, the redemptioner lost on a technicality related to the appeals process itself. Well, thank you for watching this video. If you like this, please subscribe to my channel. It's all about real-world issues, not legal or financial theory only. A review would be most welcome. And also visit my website at www.butlerevansrealestate.com, where you can see my other educational materials and also check out some of my commercial properties that I have listed for sale.